It's Entertainment Law Update, episode number 164 for January 17th, 2024. Hello, everybody, and welcome to Entertainment Law Update from Los Angeles, California. I'm Gordon Firemark.
And from the Dallas-Fort Worth Metroplex, I'm Tamera Bennett.
And we are so glad that you are here with us. This is our podcast about entertainment law, where each month we pull together a roundup of legal and business news stories and share our opinions and commentary and analysis and get around a little bit and generally have a good time. Tamera, it's great to see you face to face. We usually have been doing this on audio, but we're giving video a try this time. So
we're giving it a try. You're pushing me into 2024 or
dragging
2020,
you into
maybe.
into the new century. Anyway, what's new with you?
I love it. Oh, not much. I just wanted to wish you a happy belated birthday.
Thank you, and I believe yours has come in.
Yes, last weekend. Yeah. So we both have celebrated another year, which is an amazing thing.
Trips around the sun. It just keeps going. Yep. It's a good thing. And back into 2024, a new year, and that's exciting for all kinds of reasons. Looking forward to a prosperous one. I hope you'll enjoy yours, and I know I'm excited about mine. So that's good.
I am too, and I'm really glad I'm not doing this in my parka today, since it's the first day we're over freezing.
Oh, yes.
Since Sunday, we've had quite the little adventure with all the water dripping and the cabinet doors open, and
Oh, lovely.
Welcome to the sort of the South when it gets cold. We're not.
Yeah. I'm actually headed to Orlando next week, and I've been looking at the weather in Orlando, which everybody there is complaining that it's only in the 60s during the day. And here in Southern California, it's been in the 60s every day. So it's not even no difference. My wife got on a plane yesterday to go to Newfoundland, where she's attending a family funeral where it is, 2 degrees. So what are you going to do? Anyway, this weather has been something. But this isn't a show about the weather, so let's jump in.
It's not. Let's talk. It's actually starting off as a show about things from a long, long time ago.
Yes. Before we get into the show content, let's just quickly acknowledge our sponsor. This episode of Entertainment Law Update is sponsored by JD Supra. It's the leading platform in professional services content marketing, helping lawyers turn their expertise into networking opportunities and media visibility and new business. JD Supra publishes and distributes blog posts, articles, podcasts, videos, and other thought leadership to hundreds of thousands of subscribers on a daily basis, including business leaders, in-house counsel, media members, the C-suite, and others with a need-to-know interest in legal, regulatory, and compliance matters. JD Supra clients not only enjoy wide readership of their thought leadership, but they're also provided with the data and the tools that turn visibility into marketing and business development success. More information about JD Supra at resources.jdsupra.com.
Well, I teased it there before the ad, but we've marked another year. And what does January 1 bring every year for us copyright lawyers? Public Domain Day. So what's the big one that's fallen into the public domain this year? We've got a few. House at Pooh Corner, including Tigger. I love Tigger.
Yeah.
Peter Pan, Mystery of the Blue Train by Agatha Christie, Dark Princes by Webb Du Bois, The Cameraman, The Man Who Laughs, Mac the Knife, German lyrics only, Animal Crackers, and quite a few Walt Disney works, but the big one being Mickey Mouse, Steamboat Willie, and Plain Crazy, those two versions of Mickey Mouse.
So the operative date for copyright now moves forward to 1929. Works created in 29 or after are protected now. But Mickey Mouse, the Steamboat Willie version of Mickey Mouse was released in 1928, so in the public domain. This is the de facto face of copyright protection laws for the last 95 years, right? So this has now led, because it's fallen in the public domain, some creators jumping on the opportunity to use that character. There's been a horror-themed version of a film starring Mickey Mouse, a Mickey Mouse character. There have been NFTs, games, films, and the Adult Swim cable show or satellite show owned by Warner Brothers Discovery put out a bumper ad that features Mickey accompanying the words "public domain, bitch." So
there you go. But I mean, Disney is still doing everything they can to protect even the Steamboat Willie asset. I know we talked about this years ago when that original Steamboat Willie clip started playing on the front of pretty much, if not every Disney animated film or every Disney film, I'm not sure,
yeah,
as
effectively
well
the
as
logo.
as well as using it as a trademark. So, I guess we're just going to have to wait and see at what level Disney defends that. The current Mickey is not in the public domain. That's what's really important for people to realize.
Yeah, and we have to be careful. If someone wants to use it's funny. I joked about taking a scene from Steamboat Willie, one of those frames, and putting it on a T-shirt. And then a friend I was talking to said, "Well, wouldn't that be like a logo? And then aren't you suggesting that the T-shirt comes from the Disney company, even though the design of the logo is in the public domain? The use of the logo isn't." And so that's sort of a tricky path to navigate.
Tricky. It is a tricky path. I will say each year as it goes further and further out, it has become part of how I'm advising clients who are using music. Gosh, do you really need that song from 1932 or 1948?
Yeah.
Could we not find something that's
a little older? Yeah.
A little older that conveys the same feel you're trying to reach. And we don't have the licensing issues. And then also keeping in mind, if you're using works from the 30s and 40s, they are quickly going to fall into the public domain. What is the value of the life of the copyright? Because you're not getting it for very long.
Yeah. Good point. Yeah. So that should affect the negotiation of the price of a license.
I believe it should.
Well,
yeah.
Then again, well, you sometimes represent publishers, so maybe
I do. I do represent publishers, and I may speak about it differently. But I also would advise my clients: here's what you've got.
Yeah. It's a what's the word? What the value is declining in an asset. Anyway, depreciating asset. That's what I was trying to say. Anyway, so yeah. So anyway,
go record a new sound recording, so you have to license that.
There you go. Yeah, pull a Taylor Swift, right? Re-record all your old stuff.
That's also what I advise.
Well, there's been, as always, a lot of AI in the news this month, and we're going to cover a few of the stories. In December, we had Thaler, the fellow who had developed some material and was declined a registration in the U.S. copyright and U.S. patent offices, has also sued somebody in the UK, Daubus, D-A-U-B-U-S. Before the end of the year 2023, the UK Supreme Court, the High Court in the United Kingdom, ruled that under the UK Patent Act, the inventor must be a natural person in order to be entitled to patent protection. So this is very much in line with the U.S. court decisions where Thaler's work
Daubus was the name of his patent attempted his invention. Let's say it that way.
So his AI-based creations were deemed by the U.S. Copyright Office and the U.S. Patent Office not eligible for protection, and the same is true in the UK. So that's the trend we're seeing. But I think last month we reported that in China there has been a somewhat different view, that as long as there was a substantial human intervention in the process, that it would be entitled to at least copyright protection. So
some kind of protection.
Yeah,
he did submit a writ of cert back 2023 to the Supreme Court, where the lower courts had already ruled, no, if it's not human invention, it's not protectable. And that writ was denied. Right. So I think he's gone all the way he can in the U.S., and it sounds like if the UK Supreme Court is the highest court in the UK, he's done there as well.
Yeah. Well, until the dog is chiming in on this episode, so
Yes.
forgive us. Anyway, until enough countries, there's enough of a split and there's a need for a treaty or something to address this, I think this is where we are. And, so be it. I think I personally think it's the right decision. But, the folks that are doing complex work with AI are really putting a lot of effort and energy into it. And I sort of see their point as well. So,
yeah.
Also in the AI corner, we have the big one, the New York Times suing OpenAI, the makers of ChatGPT and DALL-E, and I think they're also suing Microsoft.
Microsoft Bing or
Bard,
whatever they're.
Yeah. They are suing for billions of dollars in damages. They're suing these entities for the unauthorized use of published works to produce the platforms, ChatGPT, Copilot, Bard, as I mentioned, and so on. And this time they are suing for billions. It's a 69-page complaint that was filed on the 27th of December. The Times asserting that these companies, Microsoft and OpenAI, are responsible for billions in damages and demanding that the large language models that used copyrighted work from the Times be dismantled. In other words, get rid of that data set. The Times has copyrights on all their articles. They accuse the defendants of blowing through those copyright protections on millions of published works. The Times says that, quote, through Microsoft's Bing Chat, recently rebranded as Copilot, and ChatGPT, the defendants are trying to free ride on the Times' massive investment in its journalism by using it to build substitutive products without permission or payment. They accuse the defendants of standing as competition to them by generating news summaries through these tools in Times' style of writing, generating responses that contain verbatim excerpts and detailed summaries of Times articles that are significantly longer and more detailed than those returned by traditional search engines, where we've seen some fair use kinds of rulings over search engine results. So the Times also argues that the use of their works is not fair use because the outputs too closely mimic the inputs without being transformative and take away from Times business. They say that when they found out about the use of their works, they tried to negotiate with these companies and platforms, but those talks fell through. And so the suit is proceeding. So on January 8th, OpenAI made a statement asserting 4 different points. Number one, that they collaborate with news organizations and are creating new opportunities. They say that the training is fair use, citing some comments from the Copyright Office website, and that this is a particular advantage for AI, but they provide an opt-out because it's, quote, the right thing to do. They say that, quote, regurgitation is a rare bug that they're working on to drive to zero. And they're, of course, claiming that the New York Times isn't telling the full story. They're saying that, look, in order to get it to regurgitate the story almost verbatim, you had to really go in and prompt it a lot in very careful, methodical ways to get it to do it. But I don't know, just because making it generate a copy is hard, it's still doing it.
It is, and it made me think of, and we talked about this in episode 162, the Headnotes case, the Thomson Reuters versus Ross, which I hadn't seen any further movement on that. But it's the same thing. The data's going in, and what is it spitting out? But did we not get the decision in the book publisher case that what was spitting out was not close enough?
Mm-hmm. Yeah.
So
look, if it's capable of reproducing exact or near exact copy, that there's substantial similarity. It doesn't matter how you get to it. And access is a given, right? I mean,
they've scanned them in.
So it sounds like copyright infringement. It sounds like this is a case of whether it's fair use and what's the policy angle going to look like, because I think you could argue both sides of fair use on this one. So I think we're in for a bumpy road ahead for a few years as we
sure. And I've tested it with lyrics before, because that's a really easy one to see if you've gotten a 1-for-1 replication.
What are the lyrics for XYZ song?
Yes.
And how'd it do?
On one song, it pulled the wrong song, but I think it gave the correct lyrics for the wrong song.
Okay. You have confusion as to which song. Okay.
Yeah, and then on another one, it was a direct infringement.
Yeah.
So they're doing a lot of training, and on some things you can't, it can
Well,
only give you the right answer.
and I think that there's a big question also about what's the infringing act. Is it the ingestion of this stuff in the first place? Because you have to make a copy of it into a system in order to work with it and learn from it, even if that copy is eventually disposed of. Although I don't know how that might. I mean, I'm not a computer scientist. Or is it on the output side where the infringement happens, which is going to be less frequent, but still, I think that the ingestion is where the copying is happening,
And that's the I'll never say it right, the ephemeral
ephemeral
copy.
recordings. Yeah.
Yeah.
Um,
How is that going to play out?
yeah. Yeah. Yeah.
Specific, I don't know to this.
Yeah. Well, you take the next one. The House has introduced
Yeah,
this.
the House bill, the House has introduced a new bill called the No AI Fraud Act on January 10th, which stands for, it's a long one, No Artificial Intelligence Fake Replicas and Unauthorized Duplications Act, aiming to establish a federal framework for protecting one's voice, likeness, image, a federal right of publicity for digital representation, doesn't go so far for all levels of federal
Mm-hmm.
right of publicity. We also talked about a similar discussion draft that was submitted in the Senate last October 2023, the No Fakes Act, Nurture Originals, Foster Art, and Keep Entertainment Safe. Is what that acronym stands for.
Can we have a No Crazy Acronyms Act?
Yeah, but we've got to come up with
Yeah.
words to go with every one of those letters. The No AI Fraud Act is based on the No Fakes Act.
Mm-hmm.
It's been praised by the unions, the privacy advocates. These always will raise concerns about First Amendment rights and free speech and creative expression. But again, like the No Fakes Act, it really deals with digital depictions, digital voice replicas, allowing for civil lawsuits and monetary damages. It has to impact interstate commerce. That's how it's a federal law. It's got to be crossing state lines, which I think anything digital, probably by its very nature, is
any transmission via internet or whatever. Yeah.
is going to fall into that category. But again, the publishing, performing, distribution, transmission of a digital voice replica or a digital depiction. And while I don't know if those terms are fully defined in what's been proposed, I think they've probably been defined in the new SAG-AFTRA guidelines to some extent.
To some extent,
So
sure,
we may be looking there to see what these actually mean. Slapping that big disclaimer on there that, hey, this isn't an infringement, doesn't count. But we're also the bill also provides, and as it should, there can be First Amendment defenses. Again, kind of going down almost that copyright fair use framework that's been set out in there. So, but there's also this weird thing about this exception, quote, you shall not be liable if the harm caused by such conduct is negligible. That just seems like drive a freight train.
Yeah, I mean, well, it could be, or it could be the equivalent of the de minimis defense in a copyright case. How often do you actually see it in practice? But
right,
because who's going to bring a case if there's no damages?
And I think that's it. How we're going to have to figure out how you calculate damages for these uses. I made a little side note. Just I have to laugh. In December, I said, "Hey, we didn't talk about NFTs much in 2023, but this would, even though I know we're talking AI, I think NFTs fall into this category.
Yeah, I think
whether
right.
that was intended or not, I think it does.
Well, this may be the beginnings of an approach to a federal right of publicity. At least, certainly in this particular subset of kinds of works in certain media. But maybe this opens up the discussion on a broader level too. So we'll have to see. This is a House bill at this point, yes? So we have to wait for the Senate. And
Yes, we'll have to wait. It'll have to be
Okay.
And I don't have the House bill number.
Yeah.
But yes, it's a House bill. So they've got to do a lot of moving and shaking to get it out of the House. And
Yeah.
it's an election year. Is this going to go anywhere?
Well, it'll be interesting to see. And maybe at the end of the year we can address that. But
Yeah.
between now and the end of the congressional session, public hearings, debates, then the House votes, then hopefully the Senate comes up with its version of a bill, and they reconcile, and then we'll see what happens. So,
Go through it.
well, speaking of, go ahead.
Well, I was just going to say, it feels like if it gets passed, though, it's going to be a little bit like the MMA, the Music Modernization Act.
Mm-hmm.
We get the law passed, but then how it actually works,
The implementation
and the rules and regulations take another couple of years.
Yeah.
Before we see it being used, but
yeah. Well, and that that's okay. It's a start. So
it's a start.
Speaking of names and images and likenesses, we have a likeness case that has come back up. The Nirvana, the baby on the cover of the Nirvana Nevermind album, Spencer Eldon, has received a unanimous Ninth Circuit Court of Appeals has reversed the district court's decision, ruling that Eldon, the naked baby on the cover, can have his day in court. Back in September of 2021, we covered this when he first filed the case. He was claiming that under federal criminal child pornography statutes, he was a victim of child pornography. He claims that defendants knowingly produced, possessed, and advertised commercial child pornography depicting him, and they knowingly exchanged value in doing so. He alleges that they failed to take reasonable steps to protect him and his widespread sexual exploitation and image trafficking. And as a result, he claims he's suffered and will continue to suffer lifelong damages, including extreme and permanent emotional distress, as well as interference with his normal development and educational progress and medical and psychological treatment. He's also claimed that he expected that the photo would remain private and that his parents never signed a release. So he's seeking $150,000 in damages from each defendant plus costs. So the district court last year dismissed the case on the basis of a 10-year statute of limitations under Title 18 USC Section 2255, but citing the Supreme Court's holding that every viewing of child pornography is a repetition of the victim's abuse, the appellate court agreed with Eldon that he could sue for the personal injuries he claims to have suffered from republication of the Nevermind album, falling within the 10 years prior to his filing the suit in 2021. So the judge in this case, Circuit Judge Sandra Ikuta, wrote, "Logically, the child pornography victim suffers the same injury whether a new individual or the original creator redistributes the image. If a victim learns a defendant has distributed child pornography and does not sue, but then later learns the defendant has done so again many years later, the statute of limitations does not prevent the plaintiff from bringing a claim based on that new injury." So, not a decision about whether or not this is child pornography. That's going to be decided on remand in the lower court. And if it is, I guess then damages is a factor, a question. I'm a little puzzled by the idea that as a baby, he expected that the picture would be kept private.
I am too, but then I'm also thinking perhaps
I'm not sure it matters.
But perhaps the broader implications of this decision might be a good thing.
Yeah.
Maybe if this were to come down that it was, I'm not making a decision one way or the other if it is, but perhaps it could be beneficial to others who could have that. Or I don't know.
The other thing is, I mean, maybe here in California, and a model or an artist or a performer would have the argument that the contract is voidable because they didn't sign. Right. Well, they were a minor. If it was signed by the minor, and if it wasn't signed by the minor, it's not binding on the kid. Parents don't have the right to enslave their children that way. So, and that's why we have court approval of minors' entertainment contracts and things like that. Although the statute of limitations on that, the voidability of things sort of expires a reasonable time after the person reaches adulthood. So
Yeah, and that's the same in Texas. I mean,
mhm.
we've had a couple of different versions, but we have one current
Yeah.
one that same thing.
Yeah.
Even if you get the parents to sign, which I believe the facts were the parents didn't sign
Hmm.
anything,
Hmm.
but they were paid.
Yeah,
So,
and the truth is, I'm not sure this photo, to call this photo pornography is, I think it's extreme. I mean, I'm sure well, I don't know for sure, but I suspect he does feel some shame and embarrassment or whatever, or maybe just chagrin at not getting more money out of out of them. But I don't think it's an exploitative photograph.
and I think it's because you see everything from the front
Yeah. Yeah.
in the photo that was originally on the
Mm-hmm.
released
Yeah.
album. So,
Well, it'll be interesting to see what the lower court does with this, and we'll be talking about it again, I'm quite sure. So,
yep, yep.
talk about this next one, French Montana.
French Montana. So this is a really interesting and fact-driven case.
Yeah.
From my point of view. So in 2012, plaintiff Eddie Lee Richardson was a 16-year-old aspiring music producer, and he, composed his own original music. Hood, Push and Wait, HPW, is the
Mm-hmm.
title of, I'm going to say, both the song and the sound recording, because that's a distinction the case
Yeah.
makes. A unique fixation, a series of sounds consisting of a snare, 808, hi-hat, rim shot, cymbal, low brass, piano bells, tubular bells, kick drums, strings, soft leads, hard leads, and orchestra hits. He was using all of his MIDI add-ins
Yeah.
to create. There is a vocal phrase of the word hot wire throughout the recording and song, but the HPW is purely instrumental. In 2012, he posted it to SoundClick, which is an online audio
Mm-hmm.
distribution platform. In 2013, defendant Carbach, also known as French Montana, not Hannah Montana, uh, released Ain't Worried About Nothing, which proved to be an immensely popular song and sound recording, reaching number 10 on the Billboard charts. Carbach admitted that he contributed to the creation of the acronym AWAN by writing its lyrics, but that other producers actually created the music for that song and sound recording. The plaintiff first heard this A1
Ain't worried about nothing.
Ain't Worried About Nothing, potentially infringing song in May of 2013, sent some type of demand via Twitter, trying to, reach a settlement, get the song pulled down. Nothing happens. Then Richardson, the plaintiff, registered his HPW. We're going to discuss what he registered
Mm-hmm.
with the U.S. Copyright Office as a sound recording. Okay, I went and I looked at the pleading,
Yeah.
which had the copyright registration attached.
Okay.
You can file a Form SR, which
For
is what he
both.
filed, and it covers both. And I say he claimed both because it listed sound recording, music, and something else
Okay.
on there. And what is music if it's
If
not
not the composition. Yeah.
if not the underlying composition? So
Yeah.
I'm kind of questioning how things got pled here. So what has been alleged and pled in the complaint was that he owned a copyright for the sound recording.
Hmm.
Uh, so after discovery, the parties proceeded to file cross motions for summary judgment. The court granted the defendant's motion in part and denied the plaintiff's motion in full, and eventually granted the defendant leave to file a second motion for summary judgment.
Mm-hmm.
And Carbach, the defendant, raises two primary arguments in his supplemental motion: that the registration of the sound recording copyright alone is fatal to the plaintiff's claims for copyright infringement because the plaintiff has failed to come forward with any evidence distributing that the AWAN copies or duplicates the original recording. It appears that we have a side note here. Did the court treat this as a claim of sampling of the sound recording versus a sampling of the song?
Yeah.
So again, defendant argues if plaintiff could establish copying, he cannot pursue his claims based on the defendant's performances. So I think that's also a key factor. I'm not sure. Well, I guess there would have had to have been a recording made if he went to Billboard Top 100.
Yeah.
But there were also performances of the defendant's song.
Mm-hmm.
So it's really an evidentiary question. Did the plaintiff come forth with sufficient evidence to create at least a genuine dispute of fact on the copying of the constituent elements of the work, which in this case, we're basing the work solely as a sound recording, that are original? Critically, the copyright in the sound recording covers the recording itself, but not the underlying music, lyrics, or other underlying content embodied in the recording. Okay, this is where Tamera's putting a pin in that and an asterisk to say, but his copyright registration said it covered
The music. Yeah, I mean,
so
when
I really don't understand. I get it if there was only there may not have been public performance infringement of the sound recording because we don't have those rights in the U.S. unless it's very limited to digital public performance. Right. But if you go through all of the standard of likelihood of confusion and so on and so forth, I don't understand why a claim wasn't brought for infringement of the song.
Yeah, my first instinct when I read the headline was, wait a minute, the judge must have missed something because the composition would be covered under the SR registration. But you're saying it wasn't pled. Well,
I did not. I read the original complaint. I didn't go back and read any amended complaints.
Okay.
But the original complaint didn't say that, even though the copyright application attached included music.
Oh, very
now, I'm making assumptions. Based on how this track is described, they're so intertwined with one another. I mean, short of if you sampled one, you sampled both. You can't sample just the sound recording and not sample the underlying musical composition because it's a fully instrumental work.
Right.
So the defendant maintains that Richardson's evidence of any similarity in melodies between the two songs is irrelevant and that the plaintiff's claims must be dismissed based on the absence of any evidence that any portion of the actual sound recording has been misappropriated. It sounds like Richardson didn't put on an expert because they rely solely on his observations of similarity. So we don't have an expert, to my knowledge. So the court finds the facts, even if undisputed, are not sufficient to create a triable issue of fact that the second song actually duplicates or samples the recording of the plaintiff's song. The mere similarity of the sounds or melodies between the two sound recordings is not sufficient to create the reasonable inference that the second sound recording actually duplicates or samples the recording of HPW because the court has concluded that the defendant is entitled to judgment on the grounds of plaintiff's failure to provide evidence of actual copying. So, defendant gets entitled to judgment as a matter of law. The court notes this is a technical win for the defendant based on the factual and legal record before the court.
Okay, so that's the judge saying, hey, could have done a better job, guys.
Yeah, and so, sorry, my notes are that the SR application covered the sound recording, production, and music.
Okay.
So,
yeah, wow.
I'm a little confused. I think they should have pled for infringement of the underlying composition.
Right.
And for the sound recording. Now, they may still not have been able to get sufficient evidence in.
Well, this was a motion for summary judgment, so it's pretty early. Well, who knows how far into discovery they got. But if there were no experts presented, I don't know.
Well, the case will be dismissed. So, I mean, short of appeal.
Yeah.
Or they refile because they did not but would not the, what's that word when it's all consumed into the complaint, even though they didn't bring a claim for infringement of the musical composition?
Preemption, consolidation. I don't
Can,
know.
either one of those are the words,
I don't.
non-litigator us, but
Well, but yeah, those other claims that are so closely related are going to be precluded in a.
right,
Yeah,
preclusion. That's
there
the
we go.
word.
Okay. Glad we could come up with that together.
Yeah, I think that's the right word. All litigators may correct us.
Yeah.
Call in and leave us voice comments.
All right. Well, we're going to move on to our next story. That's interesting. I mean, it might be interesting to see if there's an appeal, or who knows what. I don't want to point fingers at lawyers not doing a good
Well,
job
because
in
we
pleading,
don't
but
we don't know all the facts.
Yeah,
We don't
exactly.
know all the facts.
Exactly. Well, let's move on. This is a case. I will take this because I know how you are with pronunciation of foreign names.
I'm going to guess Demetrios Polykoron.
I'll take it.
Is it close?
Yeah.
Okay,
Yeah.
go for it.
Demetrius Polykoron is a Lord of the Rings fan fiction writer, and he has lost his copyright lawsuit on the sequel that he wrote to the Lord of the Rings series. Now, this saga actually centered around two intertwined lawsuits between the Tolkien estate and Polykoron. The story starts with Polykoron suing J.R.R. Tolkien's estate and Amazon for its Lord of the Rings spin-off TV series, The Ring of Power, that in April of 2023 he filed. Polykoron claimed that the spin-off TV show infringed on his book that he wrote entitled The Fellowship of the King, a derivative sequel to the Tolkien trilogy. The California court dismissed that case and ruled that Polykoron's book is an unauthorized derivative work, which actually infringed upon Amazon's prequel, and in that case is ineligible for copyright protection. Later, the court actually granted in part the Tolkien estate and Amazon's motion for attorney's fees and awarded them a total of $134,000. The Tolkien estate also filed a separate lawsuit against Polykoron in June of 2023. And based on that complaint, it looks like the Tolkien estate had already refused Polykoron's request to publish any of his work based on the Tolkien trilogy. And so the estate argued that the book is the very definition of a sequel and that it infringed on Tolkien's work by using the plot, scenes, sequences of events, setting, characters, as well as using the same mood and pace and themes with verbatim copying and close paraphrasing. So in December, the court ruled in favor of the Tolkien estate on that claim and ordered Polykoron to destroy all physical and digital copies of his book and permanently enjoining him from engaging in distributing his infringing work. So I think the takeaway is if you are in the fan fiction arena, don't go suing the original creators of the work that you're basing fan fiction on, because they're going to turn around and slap you hard.
And we've had a couple of fan fiction cases. Dr. Seuss.
Yeah, that was, well, there were a couple of Dr. Seuss cases. The Places You'll Go, or whatever, the Star Trek. Yeah.
And so I was just curious on the copyright dates. Mm-hmm. So the best I could tell from Wikipedia is that Tolkien started 1954 publishing the series, and he passed away in 1973. So there's still a long life left on those copyrights.
Yeah. Yeah. So, at least another, 30 years or so. So,
right.
And what I can tell you is that from personal experience dealing with adaptations of some of those works in other media, the Tolkien estate and the rights holders in some of those things are very careful about the way they do things. And so I think it was only a matter of time with this fan fiction work that before they would have come to him anyway and filed suit against him. So I think this is just opportunism on his end, and suing them and Amazon would, I guess maybe the best defense is good offense, but not in this case.
Get the answer to the question.
Yeah.
Resolved.
But I think the message for other fan fiction creators, look, we know that the Lucasfilm company was very tolerant of fan fiction, but now it's Disney. And so those fan fiction authors need to be really careful about don't start making claims about your work when it's based on someone else's that you haven't gotten proper permissions from.
Well, and I think it also, where we started today,
Mhm.
Find some great fan fiction published
Yeah.
1928 or early. Some great works.
Yeah. Write a sequel
Uh,
to H.G. Wells' work.
that's right. I was, heaven help us, doing updates on my website and going back and looking at Sherlock Holmes. Some of the
Yep.
things we wrote from 2013, I wrote, and we talked
Mm.
about on the podcast, from 2013,
Yeah.
when there were claims by the Conan Doyle estate against
Mhm.
infringers, and it seemed like such a long time from 2013 to 2023 when I read, but many of his works will expire
Mhm.
in 2023. And
Yeah.
so, there's lots of great works out there that you can
Well,
build upon.
and something we didn't mention when we were talking about the public domain story and Mickey Mouse is that what's really interesting is that the Disney company, most of the Disney animated features are based on public domain work. All those
Oh,
fairy
that's
tale
right.
stories and things like that. So
Yeah.
it's sort of interesting that they have done what you were just suggesting, is go find something in the history that is worth making an adaptation of and make it. And now, of course, they're able to claim ownership of those works for 95 years and from when they were created.
Well, right, because we could all go make our own version of Aladdin, the Magic Lamp, the Three
Yeah,
Wishes.
or Beauty and the Beast, or all those.
All of those works
Mm-hmm.
are great places. Cinderella.
Yeah.
We just can't copy theirs.
Right. Don't copy
So,
the look and feel, the character designs, and maybe the
that's right.
dialogue. Exactly. Yeah. So, well, we have an announcement from the copyright. Did I skip something? No.
Oh,
Announcement
no, you didn't.
from the Copyright Office about group registration of copyrights. The Copyright Office is proposing a new regulation dealing with the rapid pace at which a lot of web-based material is created. And it presents a challenge for copyright owners who want to protect their works. Online news publishers work through this on a daily, if not hourly basis, as do lots of other bloggers, podcasters, YouTube video creators, and so on. But it's the online news publishers who have expressed concern that the registration options that are currently available to them are expensive and burdensome. So the Copyright Office has taken a look at this and looked also at the benefits to copyright owners, the impact on the public record, and the office's ability to efficiently examine these works. And so they've proposed a new rule that would lead to a broader participation in the registration system. On January 3rd, they published a notice of proposed rulemaking to update regulations by adding a new option for frequently updated news websites. The new rule would allow online news publishers to register a group of updates to a news website as a collective work. And that would include the initial version of the website published in the calendar month specified in the application, along with subsequent updates published within the same month. That sounds great.
It does sound great.
Yeah.
I don't know how it's actually going to work, but it sounds great.
Well, and then the deposit would be composed of identifying material representing sufficient portions of all the works, rather than the complete contents of the website. And then the certificate would include a notation that only compilation authorship was examined. And so to qualify, the website has to be considered a news website, as defined by the Copyright Office, and I don't think that's been done yet. And the identifying material deposited has to include a sufficiently original selection, coordination, and arrangement of material to constitute a copyrightable compilation. So the notice of proposed rulemaking is open for public comment, until February 20th this year at the U.S. Copyright Office. I've already submitted some comments because I'm concerned that while this is a great step, it's just under-inclusive. It doesn't cover, because it's limited to news websites, as that is defined by the Copyright Office. I think that it ends up with the Copyright Office making essentially content-based value judgments about what should be allowed to be registered this way and what shouldn't. Sort of similar to how the Trademark Office was not allowing registrations for certain words or phrases because they were
Right.
either offensive or scandalous and those kinds of things. So I'm thinking, well, look, what about podcasters who put out an episode a day or an episode a week, or bloggers who write a post or two a day, but it's not news for whatever reason. Maybe they're, it's a knitting blog or something like that. Why shouldn't that person be entitled to the same ability to register and protect their work as the New York Times or The Verge or something like that?
And I know we've had cases in the past, primarily, I think, on defamation issues of whether or not a blogger was considered news outlet.
Journalism, yeah.
Journalism case.
Yeah.
I mean, and that's been years ago that we talked about it. So as you say that, I'm with you. That does seem very narrow. And probably the thought was, well, we kind of just want to limit the amount of filings we get.
Yeah, they've got an examination problem if they get too many of these things coming in. They've got staffing, and then they have to raise the cost of that group registration or something to make up for it, and who knows. But look, it's open for public comment, and if anybody's in agreement with me that they think it should be more inclusive, go on over and make your comments. And if you don't agree with me, keep it to yourself.
Does it has to be written, correct?
What? I'm sorry. The work has to be written.
The work has to be written.
I think so. It's unclear. I guess it could. It's compilation, so it could include the photos that are that illustrate an article as well.
I mean, I'm just thinking, let's expand it out further. An influencer who puts up how many videos, 1 a day, 5 a day on Instagram or TikTok or whatever platform it might be.
Mm-hmm. Yeah. But
how is that included? So we have more news from the Copyright Office and from the CCB regarding smaller claims cases that can be filed with the Copyright Small Claims Court. Final rules that were published on May in response to...
It's a modification of a rule.
Modification of the May 2022.
Yeah.
And the final rule sets forth regulations governing smaller claims, which are claims seeking damages of $5,000 or less. Relative to standard CCB proceedings, smaller claims involve limited discovery, optional written submissions, informal conference calls for evidence discussions, issues presented. Mm-hmm. And the amendments clarify that before service of the initial notice, a claimant may elect to change from the smaller claims proceeding to the standard CCB proceeding, or vice versa. You can go back or forth. And then there's still a process in there where you, as the other party, could just elect to not participate in front of the CCB, opt out of that. I did find, and I linked it into the show notes, an update as of October 31, 2023, kind of stats of what's been happening at the CCB since they started. Over 500 filed claims have come through. That's 1 to 2 claims per day that are getting filed. And the breakdown, I think, was kind of not quite 40, 60, closer to the 50-50 mark of this smaller claim versus a standard claim.
Oh.
And almost 50% were photographs, that type of work, picture, sculptural photography. But in the other chunk of it, it was a widespread categories of different types of claims that have been brought. So I think it's kind of interesting. I go in there and kind of watch what's happening and read what folks have to say in their filings. So, I don't know that at 18 months we have a good snapshot of how it's working.
So
I did not see was how many claims have been reached to a final.
I think it's a remarkably small number of final decisions in these cases. A lot of dismissals.
So I did not see the stats on how many claims were dismissed and for what reason, and how many actually went to a final adjudication in front of the board.
Yeah, that's again, 18 months isn't a very long time for any court to do its work, even with that number of cases coming in. So this smaller claims category is $5,000 or less. So very much like a small claims in most state systems as well. And what's the top end of the regular claims in the CCB? Like 35,000?
I'm going to say 30.
Okay.
30.
Okay. Yeah, so that's a big gap, and a lot of works are just those very small-ish infringements where it just doesn't make sense to go with the higher cost thing. What's interesting is that opt-out procedure. I'm interested in the number of defendants that opt out sort of as a bluff against. Are you really going to take me to Superior Court, to Federal Court, District Court?
Are you really going to spend that time, energy, and money to sue me and sue me in the correct place?
Yeah.
Because jurisdiction and venue may not be so convenient if you have to sue.
There's been a lot of that strategy discussion in some of the listservs that cover copyright and stuff like that, especially with a couple of the well-known. Well, I'm not going to use the word for the folks that hide under the bridges, but the copyright law firms and companies that are out there trying to collect on photo claims in particular, and some of them are valid claims, but are they big enough to justify making a federal molehill into a federal mountain?
That's right, and proving it up.
Yeah. Anyway, so that's it for this month. We've got, to say thank you, of course, to our listeners and viewers. If you're watching on video, this episode will be on YouTube for those who are interested. And thank you for spending your time with us. And special thanks to our sponsor, JD Supra, the leading platform in professional services content marketing, helping lawyers turn their expertise into networking opportunities, media visibility, and new business. You can find out more about JD Supra by going to resources.jdsupra.com. And if you have feedback for us, any comments on what we've been talking about, you need to correct us or suggest story topics, whatever it is, and we hope you do, please leave it for us using the voice widget on our website. It's over at entertainmentlawupdate.com, or you can email it to entertainmentlawupdate@gmail.com. Our Twitter handle is @entlawupdate. Our X handle is @entlawupdate. And Tamera, how can folks get a hold of you?
Yeah, Gordon, as always, super fun. And I'm glad you pushed me into the video age. So hopefully this one will show up out there in the world.
Yeah.
Folks can reach me at tbennettlaw.com. As I said, I've been updating my website. So cool. As soon as we're done, I'm going to make sure that createprotect.com still also takes you directly to my website, because I need to double check that. Most social media, I'm at Tamera Bennett, TamerABennett. Thanks again.
My pleasure. And I'm Gordon Firemark from Los Angeles. My website is firemark.com. The email address, gfiremark@firemark.com. And also, gfiremark is my handle on most social media. Let's say thank you to our crack team of contributors. We have managing editor John Janicek, Charles Thorne, Mark Lindemann, Alexis Allen, and Violet Zhang have all contributed to this episode. Thank you for your help. And if you are interested in becoming a part of the family of contributors here to help us with the show, reach out. That email address again is entertainmentlawupdate@gmail.com. And I think that wraps it up for this episode of Entertainment Law Update. So thanks again for listening. And until next time, that's showbiz.